Good afternoon and welcome. It's great to have you guys join us for today's webinar, and I just want to say thank you for spending your afternoon with us, and thank you for joining the Office of Court Administration for today's webinar. My name is Neetu Gill, and I will be today's moderator. I am the project coordinator in the Research and Court Services Division at the Office of Court Administration. The Research and Court Services Division moderates a webinar each month, and today's topic is the role and responsibility of the court coordinator in a child support court, Part 5. This is the last part of the mini-series that you have been viewing for the past couple of weeks. Prior to beginning the presentation, I would just like to go over a few housekeeping details. Please mute your microphone. If you do have a question, please use the chat box. I will be monitoring it throughout the webinar. If it's a technical question, like you can't see the slideshow or you cannot hear, I will address those immediately. And if it's a question pertaining to the presentation, we'll address those at the end. Without further ado, I would like to introduce today's speaker. She is Ms. Aurora Zamora. She's employed with the Office of Court Administration as a court services consultant. As a consultant, she offers technical assistance to courts in court management, case management, and processes. And she also provides trainings to court personnel and court clerks. Welcome, Aurora.
Welcome back. Excuse me. As Neetu said, this is the last webinar of our series, the roles and responsibility of a court coordinator in a child support court. All of the webinars have been recorded and they are going to be on our website before too long. If you missed one or more, go back and listen to them. Share them with your judge, please. Today, we're going to pick up on some topics that are a little different than the webinars part 1 through 4. Because they're not exactly on case management, they're on other topics related to our courts. So I don't want you to think that you're in the wrong webinar. These are just different topics that we have been referring to throughout the other webinars. I've been saying we're going to address that at the end. We're going to talk about that later. So this is the end. This is later. Thank you for being with us. And now Neetu will take me off camera so I am not distracting, and let's begin. Sorry about that. I was supposed to disable that feature of it coming up and sneaking up on us like that, and I did not. Using case management systems, we refer to them as CMS. OCA provides a case management system called CSCMS, a mouthful, Child Support Case Management Systems. Although CSCMS is provided to all child support courts, not all courts use it. Some courts only use the case management system or CMS provided by the county where your judge is sitting. Some courts use our program and whatever other case management system is provided by a county. Some courts use our system and an interface program that accesses a county's data, such as SmartBench. Some courts can access a county's CMS remotely, while others cannot and must rely on obtaining case information from a paper copy or an e-file distribution from the clerk. The reason that all of these different scenarios take place is because the vendors for case management software differ from one county to another, depending on the size of the county and the budget of that county. Some counties are not integrated, which means the county uses several case management system companies for different departments. The clerk may have one CMS, the jail another. This means a coordinator and a judge now have to access two different databases in one county to monitor persons from the court that are in jail. The amount of software vendors from county to county and within a county results in coordinators and judges having to use more than one and as many as 6 different case management software programs to effectively manage and monitor their caseload. The answers to our poll question in our first webinar indicate that some of you are having to access as many as 5 databases to obtain case management information for your judge. My heart goes out to you. So let's continue talking about these case management systems. The history of this software goes back to 2009. OCA decided to invest in creating a software that would allow our child support judges and coordinators to monitor all of the events and the age of child support cases. They started this by creating an advisory committee that was made up of judges and coordinators. The committee contributed to the design of the software. Therefore, the software is tailored to meet the needs of these specialized 4D courts. That's the history. Currently, the advisory committee was reactivated in 2017 under Specialty Courts Program Manager Anissa Johnson. The committee meets monthly by telephone and discusses and recommends enhancements to CSCMS, as well as recommendations on other issues relating to child support case. The creation of these webinars is a result of a need that was expressed to the advisory committee. As you increase your knowledge base of these courts and you identify an improvement or enhancement that can be made to CSCMS, reach out to Anissa. Your recommendation or comment will be shared with the advisory committee, the programmers, and the IT support staff at OCA. So in talking about CSCMS, we talked earlier, during the earlier webinars, we talked about managing information on your cases. So if you use CSCMS, you have a home page. It's called My Page. It summarizes the overview of your caseload. It gives you a list and you can access which cases are set for today. It tells you who has used that software today and what that person has done. You can broadcast messages between coordinator and judge. You can use the reminder tags. The last 2 of these, the broadcast messages and reminders, were designed with you in mind. If your judge travels, but you don't, and you're back at the office, you can monitor broadcast messages related to a specific case and reminders for instructions from or to your judge. So let's say your judge has a docket of 50 cases today. Several of those cases, she or he does not know the status of an event that occurred. She could then, or your judge could then broadcast a message for that case, and it would alert you to look at the judge's message and follow up on that event that the judge is unclear about. The CSCMS is divided into 7 sections or screens. You've got the case information, the persons, which are the parties and attorneys, hearings and documents, the orders, the child support that was set, the continuances, and the case notes. We talked earlier about using the different spaces for information when you have an event that has occurred versus using case notes. So if someone is in jail, use that space that is given and provided to you for you to indicate whether a person is in jail. If you just put the defendant is in jail as of December the 13th, 2018, you can't query or then ask the system to run a report of people that were sent to jail in December. So use the space that is provided for to indicate that that person was sent to jail. Remember, you're assembling a puzzle. The more puzzles you provide, the more informed of a decision your judge can make by looking at one screen, because most of this information is just one line. For example, in the persons section, if you enter all the children, the birth dates, the parents and their birth dates, the attorney appointed or retained, any grandparents who have intervened in this case, the service dates of the parents, in just one window, your judge can see how many children are involved in a case, how long before these children turn 18, have the parents been served, is one or both of the parents a minor who needs an attorney or who was appointed an attorney? A whole lot of information in one glance, and a lot of time saved by not having to look at a file or various screens of information on a case information from the clerk. So let's talk about data reports. Earlier in the other webinars, we talked about running reports to manage those cases your judge has. So there's various reports available again in CSCMS, and I'm sure they're also available in other case management software. Talk to your clerk. Ask them to teach you how to run these reports. Among the reports that are included in CSCMS is pending cases with age, pending expedited cases lacking service, outstanding capiases, and there is the incarcerated or people in jail. Things to remember. Again, the data that you want to extract from your case management software is only as accurate as what you have entered. The data that you may want to query, again, search and extract, needs to be in a designated field rather than in the note area. But regardless of whatever software you use, learn which reports are available. Ask the clerk for training. The reports listed are reports we have discussed throughout these training sessions. For example, identifying older cases that may have fallen through the cracks. For that, run a pending case with age, oldest to newest. It will tell you how many there are. It will list all of them. You can click on a specific case to see why it is not already disposed. Identifying cases pending service. Remember, we discussed that the OAG is responsible for service. Run a pending expedited case lacking service report. Remember, we talked about don't rely on the OAG to tell you I only have 200 cases pending service, when if you run a report, you actually have 250. Run an outstanding KPS report to ensure that all KPSs are correct. If they're outstanding, make sure that they're still valid. Nothing gives your court a bad reputation quicker than having someone arrested on a KPS that is invalid, such as in the case where the parent paid and the outstanding KPS was not withdrawn. Sometimes the sheriff's office doesn't withdraw it. Sometimes the OAG doesn't tell the sheriff's office to withdraw it. Whoever's responsible for doing that, don't concentrate on who did and who didn't. Be ahead of the game by running a report that tells you who is really out there on a valid, outstanding KPS. Confirm that someone is in jail, who is in jail is actually from your court by running an incarcerated parties report. Remember, we talked about keeping up with the dates that an individual has been in custody. So moving on, so now we've talked about a whole lot of stuff. What should I track? What should I not track? Do I have to track everything? Why is everything so important? And how do I tell that it's important? Throughout my experience as a coordinator and then later as an OCA consultant, I always use the acronym CARE. Care about what's important. Capture all that's relevant. If an event, service date, arrest date, DNA results, impacts the management and disposition of a case, then it's relevant. So how do you know? Well, is it relevant? Then care about it enough to track it. We talked about earlier about interpreters. We talked about them being necessary in domestic violence cases to lessen the fear and apprehension of parties coming before your judge who may not understand the language. We talked about interpreters when they are subject to incarceration. We want to make sure that they understand what they're committing to. Don't allow somebody to enter into a deferred commitment if they don't understand the language. So our direction comes from the Texas Government Code, section 57.002. It says you should have a certified court interpreter for an individual who has a hearing impairment, whether they are mute, deaf mute, a licensed interpreter for an individual who can hear but does not comprehend or communicate in English. In counties with a population less than 50,000, a court may appoint a spoken language interpreter who is not licensed. So maybe there's a Spanish teacher in the audience. The judge could ask that person to serve as an interpreter. In addition to that, OCA has what we call TCRIS, because we have acronyms for everything. That stands for Texas Court Remote Interpreter Service. It's a free service for courts. Some of you may already use them. We have two licensed professionals, Maria de Villiers and Leonardo Perales, and they provide interpretation for short hearings of 30 minutes or less. You can do it by speakerphone or video conference. The link is there for you to provide this. When you are looking at your cases and you identify these particular needs in this case, when you find out that there is an interpreter, find a way to relay this to your judge. Make sure that your judge knows when that case first comes before your judge and thereafter. So it isn't a surprise. So you don't have to reset a case because nobody knew there was an interpreter needed. Become familiar with which interpreters the OAG can secure for you. Oftentimes, they can secure a certified court interpreter for a hearing impaired party. Keep in mind that although you might see the OAG staff communicating with a party in a language other than English, that does not mean that the OAG staff member can serve as a court interpreter, even if the county is less than 50,000 in population size. This is an ethical issue, not a certification issue. If the staff was interpreting for the non-custodial parent, the custodial parent may say, oh, well, she's only saying that because she helped us. So never allow one of your cases to be the subject of impropriety because we weren't aware that it could cause a conflict. And the last thing, and the most important, never allow your judge to serve as a court interpreter. Throughout the first 4 webinar series, we talked about court security and reporting incidents. In 2017, the legislature created the court security director. One of the duties of OCA is to secure court security and reporting incidents. This allows for a person, usually your bailiff, to submit a report every time there is an incident. In 2017, 34 counties reported there was some security incident. I want you to look at those numbers because I want to tell you that since the legislature created that position of a court security director, those numbers have gone up. So let's talk some more about court security. Excuse me. When the legislature passed House Bill 42, it created the Judge Julie Kucerik Judicial Courthouse Security Act. It created the courthouse division, the court security division in OCA. Since 2018 January, when this bill went into effect, the number of incidents have increased, as well as the awareness for the need of court security in all courts. I know from experience that sometimes the counties do not take seriously when you have a child support court. I can tell you that this act and the creation of a court security division has increased the awareness and has increased a bailiff to be assigned to child support and child protection courts. So in addition to reporting security incidences, you and your judge must practice precautions about interacting with the public. One of the ways that we try to help in this is that with this security officer on staff, he can visit your court, assess any security risks that exist, and consult with the law enforcement agency that provides security for your courtroom. So what he does, he comes out, and this is Mr. Hector Gomez. He'll come out and he'll look at your courthouse and assess the location of desks, the windows, are access to the exits readily available? Do you need to have an increase in security? He does all this and follows up with an assessment. When the 85th legislature passed House Bill 42, they also enacted Senate Bill 510, which adds employees of state judges to the list of persons allowed to restrict public access. If you will visit this website and download the registration form, this allows you as an employee of a state judge. Your associate judge is a state judge. Your judge has either already registered or can register to have their personal information redacted from public information roles, such as the property tax, driver's license. So I encourage you to go onto this website and download the form and send it in. So you're probably asking yourself, so why should I, as a coordinator, want to restrict public access to my residence address and my information? Well, think of all the custodial and non-custodial parents that believe they have been treated unfairly in court. Either a mother who believes the judge wasn't harsh enough with the father, or the father who believes the judge ordered too much child support or sentenced him to jail. Their perceived treatment may lead them to look for answers once they leave court. Rarely, if ever, will they contact the judge, but they may try to contact you, the court coordinator. So we spoke about when do we need court security. So let's talk about when and why. During domestic violence hearings, a parent has already expressed fear of the other parent. The OG has already flagged this case as a risk. So have court security alerted of these cases, of these parties. Sometimes the custodial parent will ask your bailiff to accompany her to her vehicle because she fears the non-custodial parent that much. DNA testing, we talked about alleged and presumed fathers who may have invested years raising a child that he or she thought was his or hers. This is an emotional time for a parent to learn that the child they thought was theirs is not. Incarcerated parties. A person incarcerated for a civil contempt of court action will come into contact with individuals in jail with him he or she would never associate in public. That incarcerated person may not like your judge when they first are brought to court, or if they bond out the first time they return to court. Have the bailiff close by and alert them. The other case that you may not think about as a high security risk is the cases, multiple cases with the same father. Father has had children with 2 or more women, and the mothers are not happy learning that they will have to share the father's net income with 2 other families. This can create a court security issue. This webinar has been very short compared to our others. If you have any questions, please ask them now, or you can email us, as some of you have been doing. I encourage you to ask questions because your questions benefit other coordinators, especially because these webinars are being recorded, and we have some new coordinators joining us where some of us have retired. And so they will benefit. They won't even know what questions are there to ask. So if you have any.
Yes, if you have a question, just use the chat box and we'll get those answered. Thank you, Aurora. That was a wealth of knowledge, and I appreciate the time that you spent to go over these topics. We do have a question that has come through.
Yay!
So one of our attendees is asking, so you had mentioned court security incident reports. Now, the person's asking, can anybody submit the report, or does it have to be the bailiff? Like, say, if the court coordinator saw something happening, can I go online and submit it to?
It needs to be the law enforcement official, whether it is the sheriff's department or the bailiff. And the reason that it has to be law enforcement is because they will want to look at the incident report. If there was an incident in your court, then law enforcement will be taking a report that they will either follow up and file on that person. We need to know how severe was the security incident. So even though you may think it was not a big deal, alert your bailiff, alert your sheriff's department of every incident. Don't take for granted that because you thought it was trivial that it is. Sometimes we get so comfortable in our environment that when somebody raises their voice at the judge or leaves stomping out of the courthouse or mutters something under their breath as they're leaving, don't assume that that person is going to go chill out. That person may go and the issue may fester and come back with even more severe and serious intentions. So don't trivialize anything. Report everything and then let the law enforcement filter out the serious ones and report the needed ones.
On that follow-up question, one of the attendees is asking, you had mentioned something in regards to Senate Bill 510. Does that apply to court coordinators?
Hold on just a minute.
Will they be able to take advantage of that?
I want to make sure I know what you're talking about. We're talking about the incidents for
So the Senate Bill 510, as I recall, Aurora, it talks about the court employees.
I found it. It's Senate Bill 510, and it allows a current or former employee of a state judge to access this form and to redact your personal information just as the judge does.
Okay, perfect. And we have one more question. One of the attendees is asking that, first of all, they want to say thank you for all of the information that you provided. You went over some good topics such as interpreters, court security, and DV. Is there training on these? How can this provided good information, but can we get further training or resources? Where can we find that?
Currently, OCA is working, and I want you to know how special we actually think you are, because you are the first ones that we created webinars for. From these, we are going to create webinars on just specifically court security, just specifically on other topics that are essential to all courts, not just our child support courts. So here within the next 30 days, because of the holidays and because we are really overloading NE2, we will have a calendar of other webinars. Always feel free to reach out to me, to Anissa. If you need it, we will find it. If we have a link to a webinar that will educate you on this, we will of course share it with you. And as a side note, I want to thank all of you that have been so diligent to join us. You have no idea what that means to me. Even if it's only been 5 or 10 of you out of the 40, the 10 or 5 of you that joined us are the reason that we created these.
Awesome. Thank you, Aurora, once again. You've done a wonderful job joining us for these past 4 sessions. You provided valuable information. And I just want to put up the slide that has the contact information. Before all of you log off, I just want to go over a few details. If you, like Aurora said, if you do have any questions, please feel free to contact Anissa or Aurora. Their emails and phone numbers are listed on the PowerPoint slide. After you close out of the webinar, you will be linked to a evaluation. I please encourage you to fill those out. Once again, it just helps us grow and improve for the next webinar. And the last thing I just wanted to go over was that I will be sending out a Dropbox link that will have the recording of the webinar and the PowerPoint slides for you to view. And most likely in January, we'll be able to have all of these webinars recordings on our website, so you can check them out at any other time. With that, I just want to say thank you for taking your time out this afternoon, and I hope you all have a safe and great holiday. Bye.